Hello and welcome, everyone. Thank you for joining us here today at the Commonwealth Chamber of Commerce for a virtual fireside chat event with Peter Vaz talking about offshore funding vehicles. It's said by some experts that over half of the world's assets reside in these offshore funding vehicles, and Commonwealth offshore funding vehicles, including in Singapore, Cayman, and BVI, are amongst the world's best known globally. The reason for the popularity of Commonwealth offshore jurisdictions may in part be attributed to their shared culture, history, and most importantly, their legal systems, which are predominantly based on common law. Although many of us are familiar with the advantages these jurisdictions can provide, including tax advantages and confidentiality, many people also have a negative impression of these places due to growing costs and greater legal regulation, as well as a perceived lack of transparency, amongst other issues. So today, we're here to discuss and assess the advantages and pitfalls of Commonwealth offshore funding vehicles, and also perhaps give an informed analysis of whether they will remain relevant and important in the future and what their role is likely to be. So this is a complex topic, and we have a distinguished expert to have our conversation about offshore jurisdictions with. That's Peter Vaz. He's a partner at Loeb Smith, and he's in charge of the firm's banking and finance and corporate groups in Hong Kong. Peter specializes in corporate finance and non-contentious restructuring transactions. He advises on BVI and Cayman's law to financial institutions, private clients, and corporate entities for complex legal issues. And his performance has led to his recognition in the Asia Business Law Journal's A-list of top 50 offshore lawyers in 2022. Before working at Loeb Smith, Peter worked as an attorney at the London office of an international firm and the Channel Island and Hong Kong offices of another leading international offshore law firm. So Peter, it's lovely to see you. We're really excited to delve into this conversation. And I know it's taken out quite some of your time to put together a presentation for us where you're going to, as a kickoff, explain the concept and the formation and functions of offshore funding vehicles. So thanks so much. So over to you now, Peter.
Well, thank you very much, Julia, for that warm and comprehensive welcome. And thanks also to the Commonwealth Chamber in Hong Kong for making this possible. And to everyone that's joined us today, thank you so much for dialing in to this webinar on offshore funding vehicles. And it is great to be part of what I think is really important conversation around the role that offshore vehicles play in facilitating transactions. So I do hope that you will find this relatively short presentation interesting and insightful. Over the next 20 minutes or so, I am going to talk to you about offshore vehicles. And what I'm going to do is start by providing a working definition of the term offshore vehicle. After that, I'm going to provide a brief overview of the role of an offshore corporate law firm, following which I will explain, at least in high-level terms, what some of the key benefits and challenges of offshore funding and investment are. And as part of that discussion, I will briefly shed some light on the Pandora Papers, because that is still pretty recent, topical, and this is something you've all probably heard about. I will then conclude the presentation by sharing some practical examples of the manner in which offshore vehicles are used. So to kick things off, what exactly is an offshore vehicle? What do we mean by that term? Well, I have set out a proposed definition on the slide. Essentially, an offshore vehicle is just a business entity that is established outside of its primary location of operation. And this will usually be in an internationally recognized offshore financial center, such as the Commonwealth jurisdictions of the BVI, so the British Virgin Islands, and the Cayman Islands. And just for some context, in case you don't know where those jurisdictions are located, they are both autonomous British overseas territories in the Western Caribbean Sea. And exactly as you'd expect, the financial services sector, and certainly in non-COVID times, the tourism and the shipping sectors account for a significant majority of their income. So what do Commonwealth offshore jurisdictions, such as the BVIs and the Cayman, have in common? Well, for one thing, they are usually beautiful places to visit with a very comfortable lifestyle revolving around outdoor activities and water sports. I know that firsthand because I returned from the Caymans not too long ago. But perhaps more importantly, for the purposes of this webinar, offshore financial centers are also politically stable. As Julia touched upon already, they have a sophisticated and reliable legal system. So the legal system in the BVI and the Caymans are both based on English common law, and UK case law is therefore of persuasive authority. We have a reliable court system in both jurisdictions that is accustomed to dealing with high value and complex commercial disputes with a right of final appeal to the UK Privy Council. And we also, of course, have an excellent professional infrastructure. And by that, I mean lawyers, auditors, accountants, and all the other advisors that you may need to close a corporate transaction. So what exactly is the role of an offshore corporate law firm? What exactly is it that we do? I've set out on this slide some of the key areas of focus for an offshore corporate law firm. There are two things I'd like to clarify before I shed some light on what our role usually is across these different practice areas and the types of issues that we typically advise on. The first point is that this list is not exhaustive by any means. And there are, of course, other types of offshore law firms that focus on different types of law. So, for example, wills and probate, trusts and estate planning, conveyancing, and so on and so forth. And the second important point to note is that an offshore law firm will typically work alongside an onshore firm or a midshore firm on most transactions, simply because we only advise an offshore law and not an onshore law or midshore law, such as Hong Kong, Singapore, or UK law. So let me just touch on some of the practice areas of an offshore corporate law firm. In banking and finance deals, our role is usually to review and draft finance and other security documents being entered into by the relevant offshore companies. That is, whether they are acting as the borrower, as a guarantor, or a security provider. We also, of course, have to make sure that the directors of the offshore vehicles have properly authorized the transaction. So that will normally involve drafting and reviewing resolutions and other consents. And certainly to the extent that we are acting for the bank to issue a legal opinion on the effectiveness and the validity of all the finance documents. And I have even found that some banks that are less familiar with offshore structures may want bespoke advice on how an enforcement would work if there is a default by the borrower group. Now, corporate is obviously a very broad area that can involve advising on mergers and acquisitions, investments, joint ventures, listings and delistings, all from an offshore law perspective, and of course, drafting and reviewing transaction documents that pertain to them, such as a shareholders agreement, a share purchase agreement, a prospectus, and of course, assisting with all the corporate authorizations. In COVID times, we have also increasingly been asked to conduct due diligence on offshore vehicles that are either the sellers or the targets in an acquisition, for example, or to issue legal opinions with respect to the capacity of the offshore companies and also the enforceability of the transactions from an offshore law point of view. We then have investment funds, which of course is centered on forming and launching funds, whether that's private equity fund, a real estate fund, hedge funds, cryptocurrency funds, and of course the Cayman Islands continues to be a leading jurisdiction in that space. Regulatory is an area which has been of growing importance to the offshore legal sector, and this can involve advising in relation to entities that are regulated offshore, such as different types of funds, corporate service providers, and banks, as well as advising on the developing anti-money laundering obligations, things like beneficial ownership regulations, the economic substance regulations, and different types of reporting obligations. And I'm sure that these are things that we will touch upon in the chat following the presentation. Now, in today's climate, there is, of course, also a lot of restructuring work, both consensual and non-consensual, either usually because a company is facing liquidity issues or simply because it wishes to streamline its operations. And many corporate groups often do include offshore companies. So our assistance will be needed to make sure that the restructuring is compliant from a local law perspective, and also to assist with the restructuring mechanics. Lastly, of secretarial and fiduciary. So this is essentially about the setup and incorporation of offshore vehicles and the ongoing maintenance of them. And exactly as you'd expect, many of our client relationships start out with an incorporation and then develop from that point onwards. So what exactly are key benefits and challenges of offshore funding and investment? And in practical terms, if you have a business that has its operations in Hong Kong, for example, what is the purpose of utilizing an offshore Commonwealth structure? Well, firstly, there are definitely cost and time benefits to be had. Everyone likes efficient and cheap and cheerful, and offshore vehicles generally fit this bill. Let me give 3 specific examples of that. First of all, assuming that all KYC and AML has been completed, both BVI and Cayman companies can be set up in just a matter of a couple of days, or potentially even less. And the cost of incorporating an offshore company is usually very low, and it's also relatively cheap to maintain them. Second of all, it's also usually necessary to involve the courts and government bodies in offshore Commonwealth jurisdictions in commercial transactions, which makes offshore transactions time efficient. And so it's usually just the board of directors of relevant company, or sometimes the shareholders, that need to approve the transactions in question. And then finally, and certainly something which is not to be underestimated, is the fact that English common law, as we've already said, underpins many offshore jurisdictions, and that jurisdictions such as the BVI and the Cayman specifically are so well tried and tested, which means that they are conducive to efficient deal making, because everyone knows what to expect and everyone knows exactly how they work. Now, another reason that offshore Commonwealth vehicles continue to be popular is that they are effective in mitigating risk and facilitating transactions. So let me just give a couple of examples of what I mean by this. Firstly, offshore companies have what is known as separate corporate personality and limited liability, which are, of course, concepts developed under UK common law. For the non-lawyers, separate corporate personality simply means that the entity is distinct from its shareholders and directors. And the liability of the shareholders will be limited to any amounts unpaid on their shares, which means that they can happily invest in the company with the knowledge that they will not usually be hit with a massive liability if something were to go wrong. Second of all, from a secured creditor's point of view, offshore jurisdictions such as the BVI and the Cayman Islands facilitate enforcement action against a defaulting party due to the large number of self-help remedies that are available without court proceedings. So it makes things relatively easy. And in a jurisdiction such as the BVI, there's also a tried and tested public security registration system in place. And thirdly, offshore companies also facilitate inbound investments into countries that have restricted sectors. And so the solution which has been devised is that foreign investors often invest into offshore companies, such as BVI and Cayman companies, which then through other structures and a series of contracts enter into a relationship with relevant operational entity. And this is something that I will touch on again as we go through the slides. Now, I suppose a presentation on offshore companies wouldn't be complete without a brief section dedicated to taxation. The overarching point I want to make absolutely clear is that using offshore vehicles is not intended to facilitate evasion. Rather, the point is simply that the offshore companies are tax neutral. And that all that means is that additional taxes will not be levied by virtue of using them. So, for example, whilst many offshore jurisdictions do not have any form of direct taxation, such as the BVI and the Caymans, whether the ultimate recipient of a distribution or a dividend needs to pay tax on that dividend or distribution is a separate matter and is entirely dependent on his jurisdiction of tax residence. Now, as you would expect from a jurisdiction that is so focused on corporate and banking deals, most of the information regarding an offshore company, such as a BVI or Cayman vehicle, is confidential. Though that being said, it is possible for certain service providers, such as a law firm, to obtain limited information about a company. So in the Caymans, for instance, it is possible to get certain basic corporate information from our searchers, and also a list of the names of the existing directors. Whilst in the BVI, it's possible to get a copy of the certificate of incorporation, the M&A of the company, some basic corporate details, and also information about any charges which have been filed in the public security register. Now, I think one problem that has plagued offshore vehicles for a long time is that there is this perception that they are used to conceal wealth by the rich and the powerful, and are therefore being used to evade tax, and possibly even to conceal financial wrongdoing. And there are certain people, in fact, many people that take the view that there should be no element of secrecy surrounding offshore vehicles if there is nothing to hide. And whilst I do think that public opinion has perhaps been informed in part by the sensationalist headlines that we see coming from the media around offshore vehicles, part of the issue has also arisen, I think, due to certain offshore scandals that have occurred in the past. So the Pandora Papers are the most recent offshore leak and were published as recently as October of last year. So it's really recent. Just for some context, they comprise a leak of almost 12 million documents or 3.94 terabytes of data that was analyzed by the International Consortium of Investigative Journalists, or the ICIJ, and more than 600 journalists in 117 countries from over 140 media organizations trawled through the files from 14 different offshore service providers, which exposed information in relation to residents from more than 200 countries and territories. Now, according to the RCIJ, the individuals who are implicated in the leaks include people who use these vehicles to buy and sell property, also to hide assets away from tax and judicial authorities, and make investments in companies and banking portfolios. But it's really important to understand, I think, that most offshore structures, and certainly the ones that we advise on as a firm, are perfectly legitimate, and there are really good reasons for using them. And in fact, the ICIJ itself expressly recognizes this reality on its website, something which is often forgotten by the media. So I think it is really important to think critically about the leaks and be conscious of the fact that being implicated in either the Pandora Papers or indeed in any of the other leaks referenced on the slide does not of itself evidence any illegality whatsoever. So what is our experience with Commonwealth offshore vehicles, and what more specifically are some of the contexts in which we see them being widely used? Well, firstly, I don't think it's secret that offshore jurisdictions have historically been very popular for the purposes of listings. As one example, and as one statistic, over 80% of all companies listed on the main board of the Hong Kong Stock Exchange are incorporated in offshore Commonwealth jurisdictions, such as the Cayman Islands and Bermuda. And this is almost certainly because offshore jurisdictions, such as the ones I've mentioned, have a flexible corporate governance regime, are perceived as neutral, and also because they are well tried and tested in practice. In the asset finance space, offshore structures tend to be quite popular because they can be used to facilitate bankruptcy remoteness, off-balance sheet treatment, and they also permit limited recourse provisions to be included across documentation. I did have the privilege of acting for China's Shipbuilding Industry Corporation Leasing on its first ever ship leasing deal, so a big deal in the asset finance space, and that did involve a significant BVI law component. So I know exactly how popular offshore companies are in this space. I've already touched on the role that offshore entities can play in cross-border investments. And well, my slide is a bit of a giveaway. Perhaps the best example of this is the so-called variable interest entity structure, the VIE structure, which facilitates inbound Chinese investments. And in this type of structure, foreign investors will hold a controlling interest in a so-called wholly foreign-owned entity, a WFOE. And to comply, the WFOE does not have a shareholding in the relevant operational PRC company. Rather, what happens is that the structure is based on certain controlling and benefits transfer contracts, in other words, VIE contracts, with the PRC target company and its shareholders. Now, offshore companies are also commonly used to hold single assets simply because they are relatively cheap to maintain and offer an additional layer of confidentiality. As many of you probably know, a lot of Hong Kong real estate continues to be held by BVI companies, and other types of high-value assets such as ships, private jets, also are commonly held through offshore vehicles, simply because their owners may be high profile and want to safeguard their privacy. Now, as a firm, we have also seen offshore vehicles being used in all types of secured finance transactions, whether that's in the context of acquisition finance, leveraged finance, general corporate finance, or other types of structured finance. And many of the deals that we see in this space are incredibly complex. They involve a lot of offshore companies, and there's a lot of structuring behind them. And just to give you a flavor of how high profile some of these deals can be, I've acted on transactions such as the acquisition finance provided to Bain Capital to finance the purchase of Trans-Maldivian Airways, which of course is the luxury seaplane operator that takes everyone to their high-end resorts in the Maldives, as well as China Vanke's participation in a consortium to take global logistic properties private. That was a deal valued at around $11.6 billion US, and also Asia's largest private equity buyer at the time of the deal. So there's some really large and significant deals in the market that are being structured offshore. I've already touched on the types of corporate transactions that we are often involved in offshore, and some of the other generic advantages that offshore structuring offers, but I'd just like to build on that by giving a couple of specific examples. So first of all, BVI law expressly permits a company to act in the best interests of its joint venture shareholders rather than itself in certain circumstances, which of course sets aside the common law position that the directors of an offshore company must act in the best interests of that company itself. And of course, this can be really helpful in the context of deal making in the joint venture space. An example is the fact that rules around things like distributions, buybacks, and redemptions are really flexible and mostly only require compliance with a simple solvency test. So that has contributed to the popularity of offshore jurisdictions, particularly Cayman Islands, in the SPACs space. And then finally, the straightforward and well-tried and tested statutory merger regime in the Cayman Islands has led to Cayman companies becoming very popular in the context of privatizing Chinese businesses and companies that are listed on some of the US stock exchanges, such as NASDAQ and New York Stock Exchange. So that concludes this brief presentation. I hope that was insightful. And I'm now going to hand over to Julia, who will explain what we will do next. Julia, back to you.
Thank you very much, Peter. So that was a great overview of the offshore space. And hopefully everybody watching has a good idea of what these jurisdictions actually do. So let's jump straight into some of the granular details, shall we? And if any of the audience have questions, just put them in the Q&A box. So Peter, when did offshore funding vehicles begin? You know, when did they start to gain traction? What's the history of this?
Sure. Well, I think in Asia, anyway, it was probably at some point in the 1990s. So it goes all the way back to the 1990s. But I think it depends on whether you're coming at this through a finance, a corporate, or indeed a capital markets lens. And let me give a couple of examples to explain what I mean. So in the capital market space, in the IPO space, Cayman companies were obviously first permitted to list in Hong Kong in the mid-1990s. And ever since then, Cayman companies have very much become the jurisdiction of choice for listings in Hong Kong, but also in other places across Asia, such as Korea, Taiwan, Singapore, and even Japan. And you know, Cayman companies were successful in that space. And so following on from that, the list permitted offshore jurisdictions for listing purposes in jurisdictions such as Hong Kong has been expanded to cover other Commonwealth jurisdictions. So for example, the BVI, Jersey, and also Guernsey. Now, I think another offshore milestone, so to say, was a gradual loosening of Chinese governmental controls on raising debt offshore and also the related regulations, specifically in relation to cross-border fund flow, which resulted in a significant increase in PRC companies tapping the international capital markets, which started in 2007 when the RMB bond was issued in Hong Kong. And that developed pretty quickly. And ever since then, many bonds have been issued by a BVI subsidiary of the PRC company. Now, in a slightly different context, and since 2010, the Cayman merger law has offered a more streamlined and efficient offshore alternative to the onshore merger law regimes in taking private Chinese companies listed on NASDAQ and the New York Stock Exchange. And the popularity of Cayman for merger take privates has only ever increased since that time, particularly post 2011, when the shareholder voting threshold for approving a merger was reduced to a special resolution. And, you know, we have, even throughout COVID, seen the Cayman merger regime being proven to be used successfully in relation to the delisting of Chinese businesses on NASDAQ and the New York Stock Exchange. So short answer, probably since the 1990s at some point, but it really depends on, you know, the specific space that you're looking at.
Thanks. Thank you, Peter. I mean, my recollection is that Bermuda was started to be popular as an offshore jurisdiction for listing in Hong Kong, actually started in the 80s. And there was a lot of redomiciles to Bermuda in particular, in the late 80s, early 90s. And then Cayman started to get more popular and eventually took over. So it seems, in Hong Kong, the reason was sort of the perceived political risk at the time. And it was the Jardine Group that led the way with their first redomicile to Bermuda, which a lot of people followed at the time.
That is a really good observation. And you're absolutely right. So the significant majority of offshore companies that are listed on the Hong Kong Stock Exchange are Cayman incorporated.
Yeah, more than 50% of companies listed on the Hong Kong Exchange are actually Cayman companies, aren't they?
Yeah, I think it's actually more like over 60%.
Yeah.
But there's still a handful of Bermuda companies.
Yeah.
But I can attest to the fact that in recent times, I have not seen Bermuda companies being listed. So Cayman definitely has the upper hand now.
Definitely. Yeah, it just became much more popular. I think it was a perception that Bermuda was more expensive. I'm not sure that was actually true, but it was certainly a perception. Yeah. And I think there was a period of time when you actually had to do a technical registration of a prospectus in Bermuda, which you didn't need to do for Cayman.
Absolutely right. So one of the many reasons that Cayman companies are so popular in this space is that we don't have a separate set of listing rules, which means that the Cayman issuer can quite simply focus on the listing rules of relevant exchange and not have to comply with a second set of rules and regulations. So, we don't have in the Cayman Islands prescriptive rules around things like audits or financial statements. Instead, that will entirely be dictated by the rules of relevant stock exchange.
Yeah, you're right. So, in terms of what you see, what's the most common use for the offshore companies you see? Or is it just a variety of what you've been talking about?
No, I think it is a variety of what I've been talking about. So things, they are commonly used in the holding space. So whether that's the whole more high value properties such as real estate, ships, projects. And why is that? Well, I think it's quite simply because, offshore vehicles, exactly as I've said, are cheap to maintain. And the ongoing maintenance requirements are relatively straightforward. Of course, we also see them in the secured lending space, again, for the sorts of reasons that I've been talking about. So it's relatively easy to enforce against shares of an offshore company. And of course, it's tried and tested in practice. So banks don't need to go through a new internal process just to establish how they can enforce that security. They already have all of that in place. And then we have the public security registration system that I've been talking about as well. IPOs, I think we've discussed that. And then Cayman companies have very much continued to be popular in the investment fund space. So whether that's private equity funds but to a certain extent, we have seen some of those structures moving to some midshore jurisdictions such as Hong Kong or Singapore. So
why do you think that Commonwealth offshore jurisdictions have been so successful in terms of having offshore financing vehicles and offshore vehicles? They really are the only game in town, aren't they, when you look at offshore provision that's of any huge popularity? Why do you think that is?
Well, I don't think it's a secret that they are so well tried and tested in practice. Everybody knows how they work. That certainty is useful.
Peter, you say everybody. It's a fairly elite everybody, isn't it?
Well, but you're absolutely right. Offshore vehicles have continued to dominate in the sorts of spaces that I'm talking about. They are familiar to, anyone working with us from a Commonwealth jurisdiction. So lawyers, advisors, market participants, regulators, in the UK, in Singapore, in Hong Kong, in Malaysia, all of these jurisdictions will be comfortable relying on using offshore vehicles just because we are effectively based on common law. I think some of the other reasons that they continue to be popular, I've already touched upon. So they are quite flexible from a corporate governance point of view. For example, the company's legislation in both the BVI and the Caymans, whilst it often does set out a default provision with respect to certain provision of law, it also provides that is subject to anything to the contrary in the M&A. So you can tailor your companies however you want them. And then lastly, they are quick and cheap to set up. And tax neutral. So it is on the whole, I think, quite an attractive package.
So, I mean, it's probably fairly obvious from a sort of economic point of view that this is a business model for these islands, which, don't have a lot of other revenue. But, aside from that, perhaps you could explain for anyone who hasn't spent a lot of time thinking about it, why is it that offshore jurisdictions are able to provide this very attractive product in terms of this offshore funding vehicle, whereas most established jurisdictions from countries where they've got a lot of employees and people are paying a lot of tax and so on, they don't seem able to do this, and they don't seem able even to set up a sort of an area within a country where they could perhaps create a special zone where they could set up this type of vehicle, but they don't. Do you have any thoughts on that?
Yeah, well, that is a great question, and not necessarily an easy one for me to answer.
No, I mean, just a discussion. I mean, there's no real endless answer, isn't there? But,
yeah, agreed. But I think that some of this does come back perhaps to traditional economic theory, which of course views collecting tax as one of the key means by which governments are able to address social issues such as poverty and inequality. And the argument, I suppose, is that well-designed tax systems that redistribute wealth and provide spending on public goods are one of the most effective ways for governments to reduce inequality and poverty while sustaining growth. And of course, taxing profits of companies, as the argument goes, particularly large successful corporations, is one of the most progressive forms of taxation. It raises more income for national budgets, and when this revenue is invested in public services, it reduces inequality because it redistributes the income by putting that in the pockets of poor people. So it seems to me unlikely from a political perspective that there will be any shift away from this type of ideology in Western countries. And, I just don't think it would be palatable, given how strongly ingrained these types of views are in Western countries. Now, exactly for the reasons you've already touched upon, offshore jurisdictions are heavily reliant on financial services. And so the argument goes that a low or no corporate tax regime with no or low corporate tax rates and other incentives are helpful because they promote significant investment that outweighs revenue that corporate taxation would otherwise bring. And I think this is quite clever because if you think about it, how many companies would actually choose to invest through an island in the middle of the Caribbean if
they've
that
probably
wasn't
never
the
been
case?
to.
No, we probably wouldn't be having this conversation right now.
Yeah. So, Peter, if you were advising a Commonwealth island with a reasonable basic common law legal system, which has not really got into financial services yet, how to get started? What would you tell them to do? What would be the ingredients you think they would need to create to do this successfully?
Sure. Well, I think it all starts, doesn't it, by looking closely at what the business objectives of that client are and what is really important to them. So is it cost? Is it confidentiality, perhaps? Is it a particular point of law that the client has looked into in a specific jurisdiction that will aid its business objectives? Is it something to do with market practice and custom, or even, I've even seen in some instances a client coming to us and saying, well, we are familiar with the Cayman Islands. How would that slot in with our business? So I think it involves having a look at all of these factors and making an analysis of what jurisdiction would best meet that particular client's needs. And I can share a good practical example with you. So let's say we have a client that approaches us and shares his plans to set up an offshore Commonwealth joint venture company into which two shareholders will invest on a 50-50 basis. And the client tells us that the investments are not particularly sensitive, that they want to get the deal done as quickly and cheaply as possible, and also that the shareholders' interests are absolutely paramount. So in this case, this seems to be quite a good fit with the BVI, for example, because it's cheaper to incorporate a new company there and generally faster to do so than in the Caymans or many other Commonwealth offshore jurisdictions. Then on the point of confidentiality, even if the provisions of the joint venture agreement were to be incorporated into the M&A, for the usual sorts of reasons to avoid a conflict of interests between the contract and the M&A, then we could draft that properly. And so it wouldn't matter too much that the M&A is a matter of public record in the BVI because the investments are not particularly sensitive. And then lastly, as I've already touched on, BVI law specifically permits the JV entities directors to act in the best interests of the shareholders, which is a specific feature of BVI law. So, all those factors taken together would probably mean that we point the client towards the direction of the BVI.
So actually, that's a great answer to why a client might choose which jurisdiction. But what I was actually asking was, if you were advising an offshore jurisdiction which is not yet set up a financial services business, how would you advise that jurisdiction to go about it? One of the many Commonwealth Caribbean islands, perhaps, that has common law but doesn't have much of a financial services offering. How would you advise them to go about setting one up?
No, sure, understood. Well, look, it is obviously an increasingly crowded space with, quite frankly, jurisdictions such as the BVI being dominantly used for holding companies, the Caymans, being probably the jurisdiction of choice for investment funds. But in this age, we live in an age of digitalization. We live in an age of NFTs, cryptocurrencies, token issuances, and all that sort of thing. And so I do think that there are many exciting opportunities in that space. The BVI is very much, arguably intentionally, perhaps not, playing catch up in the sense that they don't yet have a bespoke set of regulations for these sorts of digital assets products. The Cayman Islands does have one, but many offshore lawyers regard that as being too draconian. And so perhaps there are opportunities, a happy space somewhere that sits between the BVI and the Cayman Islands.
Mm-hmm. Yeah, interesting. Yeah. And so the new products could create new opportunities. Yeah.
Exactly.
So do you think that these jurisdictions like Cayman, BVI, and we've also talked about Bermuda, will they continue to perform well in future? Are there any other contenders? Because Delaware isn't offshore, but, it's almost like a sort of enclave within the US. It functions as an offshore vehicle center, isn't it? Do you think they will manage to keep their edge, or do you think that you said before it's a crowded space? How do you think things are going to go?
Interesting question. I have to say that on the whole, I am confident. I suppose, thankfully, that these jurisdictions are here to stay. Why? Well, quite frankly, because I think it would be very difficult to find a replacement, certainly a satisfactory replacement, in terms of what the BVI and the Cayman Islands can provide in relation to the sorts of things we've been discussing. So tax neutrality, confidentiality, a flexible corporate governance regime, a reliable legal system, and so on and so forth. And actually, the numbers that we have very much back this up. So I can share some with you. In 2021, there were a total of 117,000 companies registered in the Cayman Islands, which is actually a new record. In the BVI, the volume of new incorporations, again in 2021, was almost as high as in 2018, which was actually the best year on record. So, there is no obvious sign that I am aware of that these jurisdictions are going away. Quite the opposite. It doesn't mean that there won't be any challenges. Of course, there are. I mean, I've already alluded to the Hong Kong Limited Partnership Fund, for example, which of course was introduced towards the end of 2020. And it was
about 20 years too late.
Well, but this is it. This is absolutely it. Because of course, the idea was that it would take away some of the business that Cayman has in the private equity and venture capital space. And they have had limited success.
Yeah, of course, but there's not thousands and thousands of them. Yeah.
No, it's not. It's what I would describe as a handful. And we've mostly seen it happen if you have, let's say, local investment managers who are perhaps more conscientious on costs, or perhaps if you have, PRC investors, particularly state-owned companies, that are more willing to invest in an LPF for policy reasons.
Yeah.
But definitely not the demise of Cayman that many had been predicting.
Yeah, that's right. Despite, all the onerous things like economic substance and everything, which obviously doesn't apply across the board. But, nevertheless, I think it hasn't had such an impact as one might have thought. In fact, it almost seems to become a bit of a money spinner that you can hire various people in these places, and then that creates the economic substance, right?
Well, I think it's very important to be clear about the fact that over 135 jurisdictions have implemented economic substance. And whilst each of those 135 plus countries sets its own specific rules in relation to economic substance, ultimately they are based on the framework that the EU and the OECD has come up with. And just for the benefit of those who are not too familiar with economic substance,
yeah, that would be helpful.
Essentially, what the regime does is tries to eliminate what is commonly referred to as base erosion and profit shifting. And so the idea is that you can no longer just incorporate an offshore company, book all your profits offshore, and then pay no tax whatsoever. And so what the regulations do is that they designate certain types of entities, which are pretty much all offshore BVI and Cayman companies, let's say, and they specify that those types of entities, that if they are conducting certain types of activities, then they will only be allowed to reap the benefits of offshore tax residency if they have actual substance in the relevant offshore jurisdiction. And by actual substance, I'm referring to things like premises, people with appropriate qualifications relating to the activity, expenditure in that jurisdiction, and so on and so forth. So, I think long gone are the days when you can just channel funds offshore for the purposes of tax evasion. Obviously, the economic substance regulations have made it extremely expensive expensive to try to do that. And we have seen many clients, particularly in the intellectual property space, move away from offshore for economic substance related reasons.
Right. So that sort of leads into the next question about why do you think the media, has such a negative view about offshore funding vehicles? Because I've never heard them say anything good about them.
And, the cynic in me very much says that it's because bad news is good news from a journalist's point of view. But perhaps all too often, the media paints offshore vehicles in the light that they think the public perceives them.
Yes.
But, perhaps more to the point, I think the problem is that many people still think of offshore vehicles as being secretive. And more importantly, there continues to be a lack of understanding as to why they are used and what some of their benefits are. And, if people don't understand them, then I think it's almost inevitable that they will have a certain negative around them. Some journalists are better than others. The ICIJ, for example, has this disclaimer on its website, which makes abundantly clear that just the mere implication in an offshore leak does not in any way mean that there has been any wrongdoing involved. And I think
but that's a sort of footnote, isn't it? Whereas then you read all this stuff as if there is something really juicy going on here.
Absolutely. So I think a lot of this is to do with the lack of understanding and the lack of education in this space.
Yeah, right. So what do you think people's biggest misconception about offshore vehicles is?
Well, I think that's probably that they benefit the ultra rich and the powerful only, and not ordinary citizens. I can personally attest to the fact that this is categorically untrue. We have a lot of clients that use offshore vehicles to hold one piece of property, for example, their family home in Hong Kong or elsewhere in Asia. And quite frankly, offshore companies are really helpful in assisting with the allocation of capital where needed, and not only for the ultra-rich and the powerful. I think there's also historically been this perception that they are really difficult to set up and expensive, perhaps contributing to these sort of views that only the ultra rich and the powerful have access to them, but that's not true either. They are relatively cheap and easy to set up. And then lastly, I guess another negative perception around these types of vehicles, perhaps something that the media has contributed to, is that they are used to launder money and evade tax. And of course, there have been instances of wrongdoing in the past, but I think times are changing, and we now have more robust safeguards in place than ever before. So more AML KYC collection, the economic substance regulations that we've talked about, and also beneficial ownership registers.
So you, like many offshore experts I've talked to, Peter, you seem to think that Cayman possibly has a sort of brighter, more solid future than BVI. But I just wonder, what are the reasons then behind there being more companies with active operations in BVI than in Cayman? Is there some technical reason for that?
No, I don't think that's true. I think this fundamentally goes down to the point that BVI companies, most BVI companies are holding companies. And that is a trend that has very clearly emerged because BVI companies are cheaper to incorporate and maintain than Cayman companies. And, we've already talked about the numbers of new incorporations in both jurisdictions. And that is the single reason, I think, anyway, why we have much more BVI companies than Cayman companies. Yeah,
definitely. There's a perception it's quicker and cheaper to get them. So do you have any comments about how difficult it's become to open bank accounts for these types of offshore companies? Because that's become quite a gating factor for some people, hasn't it? That it certainly wasn't, 10 years ago.
Completely. It has most certainly become more difficult. So nowadays, when we advise our clients on incorporations, we also have to have a discussion about realities of bank account opening.
Yeah, since when was that a legal discussion? But it's become one, hasn't it?
Absolutely. And from a practical point of view, it's obviously extremely important for our clients. And the realities are that it has become much harder. Some banks are categorically saying no to offshore companies. In fact, I was over in Singapore just a couple of weeks ago, and some of the Scandinavian banks still have a presence there, and the stance they have taken on it is that they will go absolutely nowhere close to BVI or Cayman companies, just as policy matter. What we tend to advise our clients is that if they have existing banking relationships, then they should use those to their advantage, leverage them. But otherwise, there are some banks in the BVI and the Cayman Islands that we do have relationships with that are receptive to opening accounts for new clients, but it's not what it was, back in the day. I mean, the AML KYC processes are extremely robust. The banks will want to see things like letters of reference. They will want to see business plans and all the rest of it.
Yeah, thanks. So I'm just looking, Peter, at questions from people someone's put questions here. So I think a couple we've sort of answered to some extent, and the other is an interesting point, which I'll come back to. But here's one. How do you feel the increased international, mainly US regulatory pressures on the future of offshore jurisdictions will change capital investment for major investors? Will it last?
Yeah, that is a good one. I mean, obviously, I think the question, in a way, is broader than just the US. And and when I say we, I mean the offshore Commonwealth jurisdictions, have come under significant additional pressure from bodies such as the EU, the OECD, of course, different anti-money laundering groups, to make sure that these jurisdictions are not being used to launder money or to evade tax. But I think on the whole, the jurisdictions have done well. The FATF, for example, that made, I believe, 63 recommendations to the Cayman Islands last year, has recently acknowledged that the Caymans have complied with 60 of them. And have almost complied with the remaining 3 recommendations. So, as jurisdictions, we understand the importance of getting this stuff right. We don't want to have another round of the Pandora Papers. Enforcement is playing an important part in all of this. So some of the recommendations were specifically around enforcement. And so although many of these bodies have acknowledged that the BVI and the Caymans have a good AML KYC framework, there have been certain deficiencies in enforcement. And it was only a couple of weeks ago, I think, that one of the largest corporate service providers in Bermuda was fined $2 million for non-compliance. So I think, the sort of enforcement mechanics, the growing list of AML and KYC requirements, economic substance. Next year, I think next year we have the global corporate tax, the 15% tax coming in as well. So I think, the BVI and the Caymans are not going to disappear into irrelevance. And they are doing a good job at safeguarding their reputation.
That's really great news, actually. It's very, very interesting to really look into this in more detail beyond the scaremongering, isn't it? So a point which Andrew Wells actually made in the Q&A, I think it's an interesting one. He was just considering what are the competitive advantages of the 3 big Caribbean offshore jurisdictions. He was thinking Cayman, BVI, Bermuda, why are they so much more successful than the Crown Dominions? But then Crown Dependencies, he answered his own question that that's differently regulated in the UK. And I know that Andrew has particular knowledge of this because he was the acting governor, I think, of St. Helena for a while, which is under the DFID, I think. So it's never been allowed to develop an offshore financial centre, which is kind of interesting. So tell me, I think we're getting to nearly the end of this, but what do you think about this UK government report on BVI? I mean, it's huge, isn't it? It's comprehensive. Positive, negative? What do you think is going to happen?
Well, so just by way of background to everyone that's dialed in, this is, a report that was completed just over a month ago, I think, on the BVI, specifically in relation to abuse of office or dishonesty that may have taken place by government officials in recent years. And the conclusion of that report was damning. It obviously found that successive governments had failed to put in place appropriate checks and balances to promote accountability and good corporate governance. And the report is, over 900 pages long and contains many examples of that. But I don't think it's all doom and gloom for the BVI. I think perhaps some of this will be fixed by putting in place, fair, transparent, and independent decision-making criteria at government level, by putting in place proper audit and accountability processes, and not necessarily by suspending the Constitution, as has been suggested by the Commissioner in the report. I do think that goes one step too far. But I think it will probably take time to fix this.
Maybe they think that's the only way to ensure this sort of happens quickly and cleanly.
Yeah, I think the reason that's been suggested is because the report has found that the problems have been going on for a long period of time, but equally, this just hasn't been looked at. This has, as far as I am aware, just come to light. And so I don't necessarily think the most draconian measure is what you would go in with at the first instance. And certainly in all of my dealings with the BVI, whether that's with the BVI Financial Services Commission, BVI Has Asia, which represents the BVI in Asia, the Registrar of Companies, I've always found them to be transparent, resourceful, and also efficient.
Mm-hmm. Thank you. That's reassuring, but very interesting. Maybe we should do a separate event to talk about all those recommendations. They're quite fascinating. Well, I think the time's gone by really quickly. That's an hour already. And so, Peter, I'd like to thank you so much for taking out your time from your no doubt busy day to share your expertise on offshore funding vehicles. It was very informative. I'm sure everybody who's listened has learned an awful lot. Thank you to everyone who's joined and interacted. We look forward to seeing you again soon. Peter, thank you again. Bye, everybody.
Thanks, Julia. Thanks. Bye.
Thanks.